monthly briefing from the Patient-Centered Primary Care Collaborative. This is Amy Gibson, the Chief Operating Officer. We're so glad that you've joined us today. As you know, the entire month we've been dedicating a lot of our topics and information that we've been sending out around the integration of behavioral health in patient-centered medical home. You know, PCPCC, since its very beginning, have always advocated strongly for this integration, and we really do believe that it's a core component of medical homes. So there's lots of resources available on our website. We're also excited to let you know that the Annals of Family Medicine this month published a new joint principles on behavioral health that will give you some additional information and some strategies. There's some accompanying articles that also came out. All of those are detailed in our newsletter. If you're not currently receiving the newsletter from the PCPCC that comes out every month, usually on Thursday morning before our monthly briefings, you can also access that information on our website. You can go to our website as well if you'd like to receive future communications and sign up to get those. So we're really excited. I'm not going to spend a whole lot of time talking too much about updates from PCPCC other than to mention again that we are having an exciting Western Regional Conference out in Denver, Colorado this June. We really hope that you all attend. We're going to have some great speakers also talking about integration of behavioral health out in Colorado. Colorado's actually been one of the lead states in really assuring that this happens, and it's due in much part to the people that you're going to hear on the call today. We're really excited today to have an incredible speaker. We've got so many of you on the call today. We do not offer you the opportunity to do live audio questions on these calls, but we do offer you the chance to type in your questions. So you should all see a little question box on your dashboard. At any point during the presentation, if a question arises, feel free to type it in. We will wait and hold off on answering your questions until our presenter has completed her formal presentation, but we'll have plenty of time. Although there are many of you on the call today, if we don't have a chance to get to everybody's question, we'll do the best job we can at posting some of those answers when we get this information up on our website. As you know, we do post the actual recording of this webinar on our website that's free to download and access at your convenience. It'll be up in about 24 hours at the conclusion of today's presentation. So without further ado, I want to encourage you to get some more information in just a moment from Polly here, who's with us. Polly Kurtz, who's the Executive Director of the Collaborative Family Healthcare Association. The CFHA, again, has been a leader in Colorado on helping practices, especially in primary care, integrate behavioral health. And I'm going to turn it over to you, Polly, to tell us a little bit more about your organization and introduce our speaker for today.
You bet. Thank you, Amy. As Amy said, my name is Polly Kurtz, and I'm Executive Director of the Collaborative Family Healthcare Association. For those of you who may not be familiar with CFHA, we are a multidisciplinary nonprofit association. We've been around for about 20 years and have a membership from across the United States, Canada, and a few members in Europe. Our primary mission focuses around promoting comprehensive and cost-effective models of healthcare delivery that really integrate mind and body, individual and family, patients, providers, and communities. Our work goes hand in hand with many of the efforts of PCPCC, and we're delighted to be able to be a part of the presentation today. CFHA really focuses on achieving its mission through education, training, partnership, consultation. We have some research and again, in advocacy. We hold a national conference. This year it will be in Washington, D.C. in October of this year. Our conference theme is From Fragmentation to Integration, a Triple Aim Imperative, and we really feel like the efforts of integrating behavioral health in primary care practices are key to the advancement of the Triple Aim. You can learn more about CFHA at our website, www.cfha.net. And I think it's, as I said, we're delighted to be able to be a part of this webinar today. The webinar itself is going to provide some practical tools and recommendations for how clinicians and other healthcare providers can better collaborate and share information within those integrated healthcare teams. in order to deliver comprehensive care. The focus is on care that treats physical, mental, and behavioral health needs of the patient. We're delighted today to have Dayna Matthew here to present on this topic. And before I introduce Dayna, I'd like to just remind you of a few things that Amy already mentioned. There is a box on your screen in which you can type in questions. We will address the questions probably in the last 15 minutes of the presentation, and this will also be recorded and posted on the PCPCC's website in the next 24 hours. So now let me tell you a little bit about Dayna Matthew. Professor Matthew joined the University of Colorado faculty in 2003 as an associate professor and was promoted to full professor in 2004. She teaches constitutional law, civil procedure, evidence, and a variety of health law classes. Professor Matthew regularly lectures to medical and public health students and is a member of the Center for Bioethics and Humanities on the Anschutz Medical Campus. In 2004, she became the law school's Associate Dean of Academic Affairs, and she served as the law school's Vice Dean from 2010 to 2011. Professor Matthew holds a joint appointment at the Colorado School of Public Health and offers classes in which law and public health students study, provide direct client representation, and advocate for changes in public health law and policy together. She's written articles on health and antitrust topics which have appeared in the Virginia Law Review, Georgetown Journal of Law and Modern Critical Race Perspectives, Michigan Journal of Law Reform, Houston Law Review, and the Wake Forest Law Review, Indiana Law Journal, and Kentucky Law Journal, and the St. Louis University Law Journal, as well as the American Journal of Law and Medicine. We are very pleased today to have Dayna Matthew join us, and at this point I'd like to turn it over to her.
Polly, thank you very much, and I want to say thank you to the Patient-Centered Primary Care Collaborative for having me, and Tara and Stacy and all that have helped me with my technological capacity. Let me see if I can advance to the first slide, and that will let me know that I'm back in control. I don't appear to have control of the slides, but I'm going to start talking in any event just so that we can get going. My objective today is to offer you some practical tools and recommendations for how clinicians and other healthcare professionals can better collaborate and share information with integrated health teams. I want to make a few disclaimers, as every lawyer must at the very beginning, and then get going with hopefully meeting my objective. First, let me say that today I will not be providing legal advice to you. Many of you are from different states, and as you will hear me describe later on today, the state laws differ very, very greatly. And perhaps more to the point, I'm a law professor, even though I am also a lawyer. I could not offer you legal advice, so this will be a discussion from my perspective as an academic, and some of it will be at the 30,000-foot level, but hopefully I'll be able to give you some practical advice as well. Secondly, I plan to use the terms mental health and behavioral health interchangeably, and I know that's not entirely accurate, so in advance I ask you to bear with me for efficiency's sake in using those terms interchangeably. And then thirdly, when I talk about integrated health, I want to say I am speaking generally to reflect any model that connects behavioral health and physical health to improve screening and treatment of mental health and substance abuse problems in the primary care setting. So those concepts include replacing an individual doctor-patient relationship with a more team-patient relationship, with a more stepped care approach that causes the least disruption in patient lives, the least extensive and least intensive and least expensive care needed to achieve positive results. What I'm hoping to do today is remove some of the panic. I know by the fact that I'm married to a physician that when he hears the word HIPAA, you, as he does, might break out into a rash, run the other direction, and I'm hoping to remove some of the panic by focusing particularly on the obstacles and barriers that have to do with information sharing. I will today talk briefly about the benefits of information sharing and coordinated care. I'll do that rather quickly. I'm assuming that the audience is on the same page, but just to give context to my comments, I'll do a brief summary of the benefits that I'm assuming. Then I will go and spend most of my time on legal barriers to information sharing. Some of them are real and some of them are perceived. So I'll start with what I think are perceived barriers and describe some things that the law already allows, and then spend time talking about the barriers that arise because the law, in fact, does embed a traditional model of behavioral health. I'll talk about that evil HIPAA law. I'll talk about state laws, which in my view are the real problem. They are confusing and dysfunctional. And then I'll speak very briefly about health information exchanges to talk about some pragmatic obstacles that could be overcome. I'll conclude with a checklist for those of you who are intending to engage in coordinated care, and perhaps a little aspirational checklist, which I will call the long game at the end of the hour. So to begin with the benefits of what we are talking about in coordinated care. As many of you already know, the United States mental health system fails to reach or adequately treat millions of Americans who suffer from mental illness and substance abuse simply because these patients fall through the cracks. The numbers I imagine are familiar to you. An estimated 26% of Americans over the age of 18 suffer from a diagnosable mental disorder. That's nearly 58 million people by the estimate of the National Institute of Mental Health. And an illustration of how this happens is not difficult to conceive. You might imagine patient X, we'll call him Xavier. This patient receives a range of services from a range of unique healthcare providers. A, from a hospital, Acme Hospital we can call it. B, from a substance abuse counselor. We could call it beta substance abuse counseling. The patient also is a patient at a federally qualified health care center where he or she is receiving HIV-related treatment. They also occasionally visit an emergency room at Acme Hospital. Of course, you can see the problem mounting here. It's not difficult to imagine that this patient's HIV status is relevant to providing quality care for the patient's substance abuse, and vice versa for any number of other diseases or maladies that this patient will face. The problem, of course, is without a coordinated care model, individual providers will not be organized to coordinate care and will not be able to share information. The solution, of course, is that mental and physical health problems, since they are interwoven, in fact, should be interwoven in a treatment setting as well. Treating common mental disorders in a primary care setting is cost-effective, but the barriers are significant. Before we turn to the legal barriers, which of course is the focus of my discussion, I do want to observe and recognize that there are other barriers besides the law. The first is time. It's very difficult to fit all of this care into a, 12-minute visit. The second, in my experience in working to integrate care in my home state of Colorado, has been the siloed practice approach of healthcare professionals themselves. We are, and I'm airing a little bit of dirty laundry from our state effort, which is, I think, quite successfully proceeding, but I have to observe that we are experiencing the difficulty of navigating the siloed mindset. Some professionals like their silos, and getting everyone to play nicely in the sandbox is tough work. There are also significant payment issues that I'm not going to focus on extensively. And finally, some of the laws that are flat out in the way won't be the subject of my primary comments, but I'd be happy to answer questions at the end of the hour. These might include building code regulations that require certain sprinkler systems, handrails, and other protections for certain types of providers while not others. These could also include different licensing requirements that are disjointed and might license addiction counselors differently from the way it licenses clinical social workers, and both of those are required to do reporting differently from primary care providers. So there are a host of laws that could be perceived as barriers. But I'll start now looking at some of the laws that encourage coordinated care, because my message, at least one of my messages, is that at bottom, the legal system is trying to move towards a coordinated care model similarly to the way that you as providers and you as members of industry are also moving. Of course, we have to start with what is called the Administrative Simplification Act of HIPAA. I can't hear you, but I imagine that there may be a chuckle there. The Administration Simplification Act is probably not very simple from your perspective, but that act was intended, at least it had its purpose, to encourage coordinated care under HIPAA, and was followed by the HITECH Act, and my screen has just taken over for me, so I'm not sure what you're looking at, but the HITECH Act, which is the Health Information Technology and for Clinical Health Act of 2009. That act provides billions of dollars for investment in health information technology. It's intended to facilitate the exchange of patient information. It's intended to employ strong incentives as well as penalties for Medicare providers and providers that will rely on electronic health records in a meaningful way. HITECH was intended to develop standards that achieve EHR technology for qualified records and to allow the capacity for clinical decision-making, physician order entry, capture and query of information, and exchange of electronic health information from other sources. Of course, the rub is the from other sources. That's the crux of the problem. Information from behavioral health populations and communities are not within the class of professionals defined by some federal and state laws, and so we'll spend some time talking about how to address those. And lastly, let me mention the Affordable Care Act itself. The patient-centered medical care home is central to the ACA. Coordinated care is a central theme throughout that statute. Examples include the Medical Shared Savings Programs for Accountable Care Organizations, ACOs, which I'm sure are familiar to you. These are examples in which the federal law, at least aspirationally, seeks to make use of care plans, of organized health information exchanges, and is looking forward and aspirationally towards moving away from what I will call the traditional model. The traditional model, on the other hand, is real. And so there are legal barriers that are real, some that are perceived, to the sharing of information. There are legal barriers that are real. Again, some are perceived, but many are not, to the actual operation of coordinated care. So let's turn to those. Confidentiality laws, especially those that pertain to substance abuse, both federal and state, and those that pertain to mental health are generally more restrictive than physical health care confidentiality laws. And I will say at the outset that while HIPAA is often cited as a barrier to information sharing between primary care and mental health practitioners, it is not really the largest barrier. Sharing information for the purposes of care coordination is actually a permitted activity under HIPAA, and a permitted activity that doesn't require formal consents. However, if it was that easy, we wouldn't be spending the next 30 minutes talking about it. The fact is that many states have mental health laws that are much more restrictive that need to be addressed, and there are some portions of federal laws that are also disjointed and contradictory with HIPAA itself. So the real barriers are those four that are appearing on your screen now. One, traditional models of behavioral health are embedded into state laws and some federal laws. And I'll give you some examples in a moment, both from a constitutional law perspective and from a statutory law perspective. Secondly, I'd like to look at the disjointed and conflicting federal laws specifically. I'll look at HIPAA as well as what is colloquially called Part 2, which pertains to alcohol and substance abuse. These laws are not well coordinated and represent a real barrier to integrated care. Thirdly, I'd like to turn for a moment to look at the complexity of state laws that are contradictory and individualized state by state, so that each of you looking to practice coordinated or integrated care will have to become familiar with your state's particular law. I'll give some examples from my home state of Colorado, perhaps California, New York, Pennsylvania. Those are the states with which I have some examples and am most familiar. And then lastly, some pragmatic barriers that are a little bit easier to overcome, I think, with time, that have to do with health information exchanges. So now turning to the first topic, the traditional model of behavioral health is embedded in the law. I'm going to skip ahead to the second slide and come back on this topic. What we call seminal case was decided in 1996. It's called Jaffe versus Redmond, and I would like to share this case with you to give you an example of what I mean by the law reflecting a traditional model of psychotherapy. Jaffe was a case that involved a police officer who underwent extensive counseling with licensed clinical social workers after a fatal shooting. It was a traumatic shooting, and the facts are pretty sordid. The estate of the deceased victim filed a suit alleging that the police officer used excessive force during her encounter and that excessive force was in violation of the United States Constitution's protections. The estate sought discovery of the therapist notes from the police officer's sessions with the licensed clinical social worker for use during trial. You can imagine how these might be used. So the issue in the case was whether the court could compel disclosure of these therapy notes from some 50 sessions. Well, the court held no. These notes are protected from compelled disclosure during discovery under the Federal Rules of Evidence. The operative rule was the Federal Rule of Evidence 501, which recognizes a general privilege, and in this case, Jaffe v. Redmond, the psychotherapist privilege was born. That is, the court recognized a brand new privilege, analogizing to the attorney-client privilege, to the spousal privilege, and the nature of a privilege, which is important to understand here, is that although not absolute, disclosure of communications in a privileged setting is very difficult to achieve. So I give you this background to let you know that the court had every good intention when it announced what has become what we call the gravamen of the traditional model of psychotherapy embedded in the law, and that is the statement that you see italicized at the bottom. The Supreme Court said effective psychotherapy depends upon an atmosphere of confidence and trust in which the patient is willing to make frank and complete disclosure of facts, emotions, memories, and fears. That's a very dramatic but a very important statement that set the tone for the way the law perceives its responsibility to protect against information sharing. That's the backdrop. The court went on to say the mental health of our citizenry is no less than its physical health in its public good nature and transcendent importance. I'm pausing to give you the language of the Supreme Court because in the legal system, it's important to note that when the Supreme Court speaks, the rest of the legal system tries to fall in line, especially to the extent that that is a constitutional pronouncement. Now returning to the previous slide. Jaffe versus Redmond set up and articulated a constitutional principle, and that is that there is a constitutional right to privacy. Now, if you sat in my constitutional law classes, you would have to see that there is actually no language in the Constitution that articulates such a right to privacy. However, in Whalen versus Roe, a case in which physicians and patients brought suit to enjoin, that is to stop the enforcement of a New York state law that required physicians to input into a centralized computer system the names and addresses of all persons who obtained certain Schedule II drugs. That case is a reflection of the Jaffe perspective that all courts now take to the law's role of protecting against disclosure, that is, protecting privacy interests. What was the outcome of that case? The New York law was upheld. The court said, we are persuaded that the New York program does not on its face pose a significantly grievous threat to either the interests to establish a constitutional violation or to violate behavioral health records. So a state may respond to a concern that drugs are being diverted. In this case, that's what New York was doing. But the court will always recognize a constitutional right to privacy in medical records. That is avoiding the disclosure of personal medical information. That's the law's orientation. That's the underlying theme that you see reflected in all of the laws that constitute what we will call, for this discussion, barriers and obstacles to integrated care. I just want to share with you that it comes from a, oh, I sound defensive, don't I, an honorable source. That said, these cases on constitutional rights have limited application. They are, to your practice, that is to say, they are triggered when a state seeks to intrude on an individual's privacy to accomplish a state purpose. Nevertheless, many cases following Whalen versus Roe and Jaffe versus Redmond have reflected this constitutionally protected traditional model of a patient and a psychotherapist, a patient and a physician maintaining confidence. That turns out to be the source of our problem. That value system, those underlying principles, are what gave birth to HIPAA. The standards for privacy and individually identifiable health information, the HIPAA privacy rule as well as the security rule, are the two rules that we'll turn our attention to now because they loom large, of course, I'm sure, in your practices. HIPAA, as you know, governs the use and disclosure of an individual's protected health information. I'll call it PHI from this point forward. It applies to what are called covered entities, which essentially is any healthcare provider who transmits health information in an electronic form. It's broader than that, but that's generally who is covered by HIPAA. HIPAA protects an individual's privacy rights to understand how their health information is used, when it's used, and to control its use. The legislative goal, that is to say what the Congress was intending to accomplish when HIPAA was drafted, was to strike a balance between assuring that individuals had their privacy protected in keeping with those constitutional, very weighty values that I suggested earlier, and on the other hand, to allow the flow of health information needed to provide and promote high-quality health care, all while protecting the public's well-being. Well, at the outset of our call, I suggested that HIPAA is not as much in the way as you perhaps think at this moment, and that is because HIPAA does, as you well know, permit the disclosure of PHI for treatment, payment, or healthcare operations. There are some circumstances when the use or disclosure of PHI is perfectly permissible, and it can be done without patient consent. Of course, the problem is discerning what those instances are, and the further problem is that each provider will interpret these permitted disclosures differently. So at the end of the hour, one of my recommendations will be that in your respective states, you hold educational and information settings with an attorney that you respect to help you understand exactly the extent of the permitted disclosures that HIPAA allows. They will cover a number of settings in which coordinated care providers, in my experience, are needlessly nervous and could be helped and served by just understanding a little bit more as a practical matter of what integration can occur today. I'll give you two examples. A behavioral health organization may today qualify as a business associate under HIPAA. That means that behavioral health organizations and their contractors, though covered by federal HIPAA laws and the regulations, when they are business associates, may disclose protected health information and allow the BHO to create and receive protected health information if the entity has adequate assurances that the BHO will safeguard that information as a business associate. How do you do that? By entering into a business associate agreement. For those of you that are lawyers, you would cite 45 CFR 164.504E. That section covers business associate agreements. A second example, collaborating professionals may qualify as organized healthcare arrangements. Organized healthcare arrangements is a term defined by the HIPAA rules as a clinically integrated care setting in which individuals typically receive health care from more than one healthcare provider. Again, for lawyers among you, I'm going to refer you to 45 CFR section 160.103. These organized healthcare arrangements include an organized system of healthcare where one or more covered entity participates, engages in a joint utilization review, engages in quality assessment and improvement, and payment activities that are jointly coordinated. Now, of course, those are loaded legal terms, but my point is to tell you that there are entities, there are agreements which could be drafted today under current HIPAA regulations that will allow these relationships to proceed and allow information sharing to occur. The HIPAA security rule covers these types of provider arrangements, these agreements that I referred to, and the HIPAA Administration Simplification Statute that I referred to earlier in the hour are standards that are integrated to allow and ensure the integrity and confidentiality of information, to protect against any reasonably anticipated risks to the security of the information, and to protect against unauthorized disclosure. In other words, you can get an agreement drafted for some of this information today. Now, that said, the HIPAA privacy rule does, however, contain limitations. The first, of course, is it limits sharing of psychotherapy notes without a patient's written consent. This is a very significant restriction. The site is on your screen, and it is significant not only because it's broad, but also because there is not a great deal of uniformity and agreement as to what goes into psychotherapy notes. Health information exchanges do not clearly delineate what sections or components of electronic health records contain psychotherapy notes. And so we are in a transition period of understanding how to operationalize this limitation, which constitutes a very significant obstacle and barrier to coordinated care. Perhaps the most significant barrier and obstacle to coordinated and integrated care under the federal law is the thorny problem of coordinating the HIPAA privacy rule with what is called Part 2, 42 CFR Chapter 1, Subchapter A, Part 2. Part 2, as I'll call it for the rest of my discussion, prohibits the sharing of medical information for patients in alcohol or substance abuse treatment. I've listed for you the broad range of medical records that are covered under Part 2. Prescriptions, monitoring notes, counsel session start and stop times, furnished treatment modalities, results of tests, summaries of diagnoses, treatment plans, and on and on and on. I list these in order to, I guess, provide a counterbalance to my optimistic outlook at the beginning of this discussion. HIPAA allows much more than we are acknowledging. The law is very eager, at least in its transition to supporting integrated care, it appears. Well, the fact of the matter is that we've now hit the speed bump in our discussion. Coordinating HIPAA privacy rules with Part 2 is a very significant obstacle to coordinated care. The conflicts between the privacy rule and HIPAA, HIPAA privacy rule and Part 2 are treated in a guidance that is put out by SAMHSA, and I put that on your screen. The the URL that will give you the guidance to show some of the ways, or frequently asked questions, I will say, that are that provide solutions to the conflict between HIPAA and Part 2. Having said that, let me now turn to the ways that it is currently possible to electronically share both primary care or preventative health care records and drug and alcohol treatment information while meeting both the requirements of HIPAA and Part 2. So I'd like to talk now about some practical ways of navigating the complexity of the conflict between HIPAA and Part 2. First, of course, there are qualified service organization agreements. And I have to admit that as I go down this list, there will be several times when I am saying a lawyer can draft these for you, and I sound a little bit like I am the Equal Opportunity Employment Act for lawyers. But these agreements actually are permissible under the statute, and they can be drafted to accommodate integrated care. So the Substance Abuse and Mental Health Services Administration, which I call SAMHSA, governs what are called QSOAs, Qualified Service Organization Agreements. They cover the fact that unlike HIPAA, Part 2 doesn't operate to permit the disclosure of what we call payment treatment or healthcare operation information. Part 2, with limited exceptions, bars the sharing of that list of information that I talked about earlier. So in order to accomplish the kinds of exchanges that are permitted under QSOAs, you would want to draft an agreement under Part 2 where a program makes certain acknowledgments that it is, that is the primary care provider, it is operating consistently with Part 2. Just to give you an example of what those QSOA valid written agreements would look like. The program, let's say it's a primary care provider, would acknowledge that in receiving, storing, and processing or otherwise dealing with any patient records from Part 2 programs, it is fully bound by Part 2 regulations. The program would also have to indicate that if necessary, it would resist judicial proceedings in any efforts to obtain access to Part 2 information. These agreements are similar to, but not quite identical to, the business association agreements that I referred to earlier under HIPAA security and privacy rules. But any attorney who is familiar with drafting those business service agreements could also draft a QSOA. Examples of services that might be included are holding and storing data, reviewing and receiving data, responding to requests for third party, and of course using that information consistent with Part 2 for treatment. Returning to patient X, in my initial example, that patient's federally qualified healthcare clinic as well as hospital or the substance abuse provider might, under a QSOA agreement, have the ability to communicate information consistent with both HIPAA and Part 2. Secondly, if a Part 2 program is has administratively been controlled by an information sharing agreement with a non-Part 2 organization, that administrative control can serve to protect or envelop or provide an umbrella for the disclosure of information by the non-Part 2 organization. So in short, a Part 2 organization is not required to consent or to get consent when the information is exchanged within a program that has administrative control over the Part 2 program and has agreed to abide by the Part 2 regulations. So when a substance use disorder unit is a component of a larger behavioral health program, or a substance use disorder unit is a component of a general health program, Specific information about a patient arising out of the patient's diagnosis or treatment or referral can be exchanged without patient consent among these Part 2 programs personnel members and with administrative personnel who, in connection with their duties, need to know that information. Again, for those lawyers among you, I'm going to refer you to 42 CFR Section 2.12, subsection C, subsection 3. Of course, there are some other models that we call patient choice models, opt-in and opt-out models for HIOs, for health information organizations. Those have limited protection for Part 2 sharing. They're on the list just because they do provide some protection, but very minimal protection. And of course, by declaring a medical emergency, Part 2 information can be shared, or the standby of getting patient consent. So it is a complex, conflicting territory that is navigating the federal laws that are disjointed, but it is not one that could not be achieved. Let's turn now to the issue of state laws, which, as I said in the very beginning, I believe are the most egregious offender, if you will, of making a barrier or creating an obstacle to integrated care. HIPAA provides for the preemption of state laws that relate to privacy and are more stringent than a standard required or implemented under HIPAA. The problem that this creates is that U.S. providers must check every single state confidentiality law in which you operate. This leads to confusion and impedes coordination of care within the state and between providers, without question. HIPAA's preemption rule necessitates an assessment of state law. Having said that, HIPAA also defers to state laws that are not more stringent. So state laws which are in themselves inconsistent with classes of healthcare professionals being defined differently in my own state. A licensed social worker is different from an addiction specialist, is different from a psychotherapist, is different from a clinical psychologist, is different from a psychiatrist, and all of these might provide exactly the same care under a different set of regulatory rules. The exceptions to enforceability for state laws are also highly specialized, highly individualized, and very often in conflict with the care and the confidentiality and privacy laws at the federal level. The penalties for noncompliance are inconsistent. The disclosure requirements, the reporting requirements are inconsistent. And my message here has got to be, I can't say it frequently enough, has got to be check your state law, check your state law, check your state law. If we have time, I'll give you some examples, as I said earlier. In order to leave enough questions for time for questions, let me go then next to the barriers presented by health information exchanges. Electronic health records don't define psychotherapy note components or any other components separately enough at this stage in our evolution of EHRs to give us a really clear and crisp way to determine what HIPAA requires, what can be disclosed, and to isolate that which can be disclosed from that which cannot be disclosed. This is a physical barrier more than it is a legal barrier, but it is one that can be solved today, and I'll give some ideas about how that might be done in a moment. Let me also say that in using the current versions and generations of electronic health records, physicians are not consistent in where they record patient information, and we don't have a standardized, we haven't developed a standardized method of defining different categories of information so that they can be identified and isolated for disclosure when permitted. And EHR vendors themselves are not yet keeping up with coordination of care reforms or the laws as a matter of technology. The programs and software are not yet speaking to one another and are not speaking the language of disclosure quite yet. I will say that we are in a transition, and that transition holds a fair amount of promise, since health information exchanges do support a broad collection of health information that is necessary for coordinated care. They provide a pathway for achieving real-time exchange of information. But at the same time, the exchanges themselves are not HIPAA compliant or even subject to HIPAA, and so there are incongruities between HIE operation, the privacy rule at the federal level and at the state level. So let me conclude by suggesting, if you are seeking to achieve coordinated care and overcome the barriers and obstacles that exist under the law today, particularly to information sharing, you might just follow a checklist. First ask, is there a constitutional right to privacy that protects the information or the confidentiality that is at issue in your patient population? These, again, will be those instances in which a state actor is seeking to disclose publicly information to or on behalf of the state. Secondly, of course, you'll look at HIPAA and its implementing regulations, and I'm speaking of those that are permit the sharing of treatment, payment, and health operation information. Of course, thirdly then, you would have to determine whether you are integrating your health services with a federally supported substance abuse program. If so, those thorny Part 2 laws will kick in, they'll be triggered, and it will be required that you use one of the tools that I mentioned earlier for overcoming the obstacles between HIPAA and Part 2, or find another tool that is patient consent. I want to mention quickly that student campus clinic health records are exempted, and if there are questions about this later, I can speak to that very specialized exemption. And then lastly, and perhaps most importantly, you will have to look at your state's constitution, your state's confidentiality legislation, the drug and alcohol treatment statutes in your state, disease-specific legislation, for example, HIV/AIDS legislation in your state, and state case law. The long game slide has a quote that's cut off, and it says, "Nancy, I don't think that's what HIPAA had in mind," and it's my way of concluding our conversation, my presentation that is, by suggesting that there are some ways that HIPAA is having an unintentional effect, that the federal laws and the complexity and contradictory dysfunctional nature of state laws is having an unintended consequence. But there are some states that have found ways to solve these problems. And I don't know how many of you might be from Illinois, but one of the statutes I most admire at this stage that has facilitated information sharing and has been changed recently in order to accomplish this is an Illinois provision called the Disclosure for Treatment and Coordination of Care. I like this statute because it refers not only to state law but federal law. It refers to covered entities from jails to insurance companies to integrated health systems. I like this law because it defines integrated health systems in much the way that I think this group would do so, and it does a great job of coordinating the information sharing in a way that I think other states could follow. So when I think about the long game, when I think about things that we could do that are not immediately possible, I want to include looking for or advocating for the reform of state law to clarify the fragmented regulatory system that exists within states, as well as to clarify the contradictory and dysfunctional law that exists at the federal level. I have to call this the long game because I don't think it's going to happen overnight. There are, as I said earlier, lots of other laws that are in the way besides privacy and confidentiality rules. I think we have to reconsider reimbursement and payment systems. We have to critically evaluate restrictions such as same-day billing restrictions, which we have in Colorado. We have to align professional licensing laws, the duties and regulatory obligations under licensing laws. We'll have to coordinate conflicting building and construction codes, which oddly present a very significant barrier and obstacle to care. And certainly, practitioners will have to lead the charge for pushing for free exchange of information, its benefits, and its positive effect on healthcare quality and costs in advocating for these changes in the law. I hope to see vendors of EHR systems build the capacity to filter and segment in ways that I referred to earlier. I hope to see lawyers help to review and revise legislation that hinders the coordination of care. I'll close by saying that in order to balance the legitimate protection of privacy and security interests against the need for coordinated care and to achieve quality care at a cost savings, it will require a coordinated effort. Thank you.
Thank you, Dayna. What a fantastic presentation and wealth of information. As you've been talking, we have had a large number of questions come in, and it looks like we just have a few minutes left to try to address some of these. So let's get started. One of the first questions has to do with, given all of the barriers discussed today, Dayna, what do you see as the single most important obstacle to collaboration?
Thanks for that question, Polly. I have to say that although I spent most of my time on information sharing and privacy, I did that strategically because I see so many ways around the perceived barriers. And I see it as such a strong concern among the practitioner community in my state that I wanted to have an opportunity to address some of the things that I think are perceived and some of the things that I think are real. But the largest barrier I think that has to come down is reimbursement and payment barriers. I think those are the real problems to coordinated care, and after reimbursement and payment barriers are removed, I think a lot else will fall into place. And when I say those reimbursement and payment barriers, I'm referring to some things like the same-day billing restriction. We actually have a restriction in Colorado, and I imagine that people on the call have these in their states as well, but the restriction prohibits the reimbursement under Medicaid and Medicare for a physical or primary care service on the same day as a mental or behavioral health service is provided. That's just boneheaded. That's wrong. That couldn't be a bigger barrier or an easier one to overcome. So I would say reimbursement and payment systems have to change before we really have integrated care.
Excellent. We have another question about PHI going from physician to physician across state lines, and where there are different privacy laws in place. Do you have guidance for practitioners who are dealing with that situation and which state law takes precedent?
Yeah, that actually is a really excellent question. There are two parts to that question. The question as to what state law takes precedent is one that is very fact specific. And so it depends, of course, where the care originated, the balance of distribution of how much care is provided in each state by different providers. I can think of instances where there are contiguous state borders where it's very common. I used to live in Kentucky, and going between Kentucky and Indiana for care was very easy, and so it happened frequently. And so the balance would be different than if you're speaking of someone who has care initiated in California because of a job move, transfers across country, and the question arises when they arrive in New York City for their new job where they will stay. So those facts are very different and would yield up different answers with respect to the second part of this question, which state takes priority. In a nutshell, it's the state where the patient would be domiciled. And that's a legal determination that you would have to ask a lawyer to make. But to the first part of the question, are there guidelines, are there problems under HIPAA with sharing information across state lines? It is not HIPAA that provides the obstacle. It's the differences in the two states' laws that would provide the obstacle that would need to be overcome. And the entity that is concerned with integrating with another entity should get legal counsel that is able to interpret the laws of both states for that problem to be resolved.
Very good. Very good. Thank you, Dayna. In just the last couple of minutes, and I do want to note we have, as I said, a number of questions today that we will not have time to address, but all of these questions will be logged, and we will be consulting with Dayna, and I believe the PCPCC will be responding to those of you who have registered these questions. So just in the last couple of minutes, we do have a question about patient consent and electronic referrals. So Dayna, if a patient's referred by a primary care physician to a behavioral health specialist electronically, can that behavioral health specialist send notes back to the PCP electronically without the patient consent?
Let me understand the question again. So a patient is referred from a behavioral health specialist to a PCP, and the question
actually the opposite way, from a PCP
okay.
to a behavioral health professional.
And the question is, can the notes go without patient consent?
Correct.
If there's no agreement between the PCP and the behavioral health specialist, they cannot. If there is an agreement, then they can, and some of the agreement components would be such as I described earlier. However, it's not difficult to get patient consent for those notes to travel. Just the name on the consent, which would follow the Code of Federal Regulations, the name or the general designation of the program that is receiving these notes, the title or name of the individual patient, the purpose of the disclosure, and what kind of information, psychotherapy notes, would be the really sort of bottom line building blocks that would have to appear in that consent. The patient would sign. If the patient is a minor, of course, there's a different set of regulations for that, and date the consent, and then those notes could follow with the patient's permission.
Very good. Thank you again, Dayna. And thank you again for an outstanding presentation today. I think you've left us all with lots of information that we'll want to go back and review in order to help us navigate that. It's really challenging situations in our practices. And thank you all as an audience for participating in today's national briefing. We hope you can join the next briefing, which I believe is April 24th. And as a final reminder, all of the slides and the recorded presentation will be posted on the PCPCC's website within the next 24 hours. Once available, you can access them at www.pcpcc.org/webinars. Thank you again for participating today, and have a great rest of your day.